Hello and welcome to our employment law catch-up. Part podcast, part webinar, a bit of a romp through some recent and interesting cases. My name's Heather Platt and I've been a barrister for 21 years. And I specialise in employment and discrimination law. And today I have with me Oliver Foy and Louisa Simpson to talk through some case law which we think you'll find interesting and useful. Our focus today is on the Employment Rights Act 1996. And I should say at the outset that we're talking about cases which involve people who've lost their jobs. And the cases we're looking at today took place in 2020, which of course were very uncertain times for most people. And I suppose the point I'm trying to make is that these are real people and their lives and their families that we're talking about today. We're focusing on the legal issues and the importance of the cases, which is what employment lawyers are interested in. But I did want to say at the outset that we don't mean to trivialise the significance of how it feels to lose your job or how difficult that is. Of course, we act for both sides in tribunal litigation for employers and employees, and we absolutely understand and acknowledge that litigation is difficult and challenging for everyone. After all, we're talking about people and the decisions that people make at work, and we always try to be respectful and mindful of that. So, Louisa, let me introduce you. You are an employment law specialist and civil litigator. You joined Chambers last year, and you have particular interest and experience in employment regulatory and personal injury work. You now have under your belt multi-day final hearings for all kinds of discrimination and Employment Rights Act matters. I think you've acted for professionals in professional misconduct claims against regulatory bodies as well. And quite unusually, perhaps you've got lots of experience in non-contentious work as well as advocacy in tribunal. Is that a fair summary, Louisa? Is that your journey today?
It is definitely up to date.
Great. Okay. And so the case that we're going to be looking at today, Louisa, can you just introduce that for us and tell us a bit about it?
Yes. So it's the case of Dunbar and Abellio London Ltd. So that respondent's name might ring some bells for some people. They're a TfL London bus driver company. They employ the bus drivers, or some of them. And it essentially was an allegation in relation to a refusal to return to work in unsafe conditions, or what were said to be unsafe conditions. So obviously we were, as you said, Heather, talking about 2020 and the pandemic, and those were the circumstances which were said to be unsafe for claimant, he said, to work in.
Yes, and the case is, of course, it's in the public domain. We won't be asking you to reveal any confidential information about this or your instructions, because you were instructed by the respondent, weren't you?
I was, yes, for the bus company.
Yeah.
And also there was obviously quite a lot of controversy at the time and a lot of news around the particular dangers and difficulties that bus drivers had, you know, and I know that they, for example, had perhaps higher death rates, and it was obviously a very, very difficult time for them. So quite an important, I think, case.
Yes. So can you just help us with what the legal framework is then? What sort of law were we looking at here?
So it was brought under section 100 of the Employment Rights Act, 101 D and E specifically. So really we were looking at D, which is, as I say, essentially a refusal to work in unsafe conditions. So breaking that down a little, it relates to cases where there are circumstances of danger, firstly. So that was the pandemic. Secondly, the claimant has to reasonably believe those circumstances of danger are both serious and imminent. The claimant mustn't have been able to have reasonably averted those circumstances of danger in some other way. And what the claimant has to have done is to refuse to continue to work or to return to work while that danger persisted. Yeah. And in those circumstances, if that and their refusal to work is the principal reason that they are dismissed, then that is automatically unfair under section 101D. Just very briefly, the case was also brought under subsection E. And And I'm going to mention it briefly because that's not what the case was decided on, but there was a bit of an interesting, I think, legal point raised and determined that I know of, I think, for the first time, which is that, so E is almost the same, except that instead of refusing to work while the danger persists, it relates to the claimant taking some other appropriate step to protect themselves from that danger. There are some other differences as well, but that's the main one. So what the claimant did in this case was refuse to return to work. And I argued, and the judge found actually that leaving or refusing to return to work can't also be an appropriate step under section 101E. So it has to be, it's an either or situation. You can't rely on both of those. So that's why I just say I touch on that briefly.
Yeah, that is interesting. I remember Ollie and I actually wrote a blog piece about this particular section because it's so little used really on a day-to-day, that we thought, didn't we, Ollie, that this was going to become more significant, and obviously it has during the COVID pandemic.
Yeah, absolutely.
So so your role in the case was you were the barrister who represented the bus company. Just take us back, Louisa, because we're going back to COVID times. We've happily forgotten all about it now, 3 years on. But start of March 2020, when this all took place, or when things started to unfold, just remind us where we were in terms of lockdowns and so on.
Yeah, I had to have a look back and remind myself about this, actually. It seems so long ago now. But I'm sure we will remember some of the first major dates, which was the 16th of March. The government advised to stop all non-essential contact and travel. And that was kind of really formalised on the 23rd of March when we went into a proper full-on lockdown. We were ordered to stay at home. The case actually revolved around a slightly later period when we were going into the summer of 2020, when things did start to be relaxed a little bit for a while anyway. So on the 10th of May, if you couldn't work from home, the government said that you could return to the workplace, but you were still advised to kind of avoid public transport and things. About the 1st of June, the schools started to reopen on a phased basis, but we still had social distancing rules, 2 metre rules in relation to meeting up with anybody or being near anybody outside and things like that.
Great. And can you tell us a bit about the facts of this particular case then?
Yes, so the claimant was employed by the respondent as a bus driver. He lived with somebody who was shielding, and so the respondent company, they furloughed a number of their bus drivers in March when we first went into lockdown, because obviously we were told to stay at home and there were fewer buses running and fewer people that needed them. But as I say, in about June 2020, things started easing a little, and the claimant was asked to return to work. He refused to do so and said that he was concerned about risks to his family of the virus. Obviously, he was living with somebody who was particularly vulnerable, and so those were his worries. What the respondent said was that they had undertaken a number of risk assessments. They'd complied with government guidelines, and they had done things like making sure they disinfected the cabs where the drivers worked. They had closed up, and I think we still have on the buses now, closed up the kind of gaps between where the drivers have to sit and anybody gets on the bus, and provided gloves for them to wear and hand sanitizer and things. So they said that because of that, they thought that it was reasonable to ask him to return, and it wasn't him himself who was shielding, but somebody in his household. And so the government guidelines were that he could return to work and continue to be out and about a bit. Unfortunately, he didn't feel that he was able to return to work, and the respondent put him through an unauthorised absence procedure. It resulted in a disciplinary hearing, and he was dismissed for gross misconduct, which was failure to or unauthorised absence, at the end of July 2020, which was then upheld on appeal in September, and he issued the proceedings in about November.
Understood. So what was the reason that he was dismissed for? What was the reason that was given by the bus company?
So it was gross misconduct, which was specifically continued unauthorised absence from work.
Understood. And what were the legal issues then that the Employment Tribunal had to decide?
So as I say, Section 101D can be sort of quite easily broken down into the different aspects. So they were looking first at were there circumstances of danger, and that was brief because on behalf of the respondent I accepted that there was. Obviously we're talking about it being in the midst of a global pandemic. I think it would be very difficult to have said that there was no circumstances of danger. So what was important though was that the judge had to decide, did the claimant reasonably believe that those circumstances of danger were both serious and imminent?
Yeah.
And then could he have reasonably been expected to avert those circumstances of danger? And those were the main real issues, because then did he refuse to work while the danger persisted, and was that the reason why he was dismissed?
So in terms of the reason for the dismissal, it's focusing on whether or not the steps that he's taken then led to the decision to dismiss.
Yes.
That causal link, isn't there, that's quite difficult to establish, I should think.
Yes, and quite difficult to, I think, differentiate between the claimant saying I was dismissed because I refused to work when there were circumstances of danger, and what the respondent is saying that he was dismissed because he refused to return to work. So there's an element of crossover there, but what we as a responding to that claim have to focus on is that it relates very much to the circumstances of danger. Were they serious? Could they have been averted in a way other than refusing to work?
Yeah. So what did you notice any strengths and weaknesses at the outset that you can share with us? I mean, obviously I don't want to give any privileged information away, but what were the strengths and weaknesses in the cases?
I did think actually it was quite a strong case from the outset for the respondent. There was one other COVID-related dismissal, Section 100 case out at the time. It was an EAT case. It's Rogers and Leeds laser cutting. And in that case, the Employment Tribunal found that the claimant, that his concerns are about the pandemic at large and as a whole, rather than specifically about dangers to do with his workplace. And so that claim had failed. So I saw quite a lot of similarities between the two cases, and I thought that in those circumstances it was quite, we had quite a strong defence. The claimant, I think, had obviously or perhaps done some research before proceeding with the final hearing, and had then, when it came to the trial and witness evidence, focused quite a lot more on the specific workplace dangers, which I think there definitely were more of in this case than in the Rogers case. So that was, a potential issue. I mean, one other potential issue that I identified, which can be quite common in other cases as well, was that the disciplinary hearing actually went ahead in the claimant's absence.
Uh-huh.
And I thought that was a potential concern, because obviously the issue was around his failure to return to work, and they had asked him to return to work in order to attend the meeting. They hadn't suggested that it take place remotely, for example. So I thought that was an area that we would probably have to look at and explain. But I also thought it was mitigated by the fact that there was an appeal hearing that was heard, and the claimant was present for that. So it seems to me that the outcome wouldn't have changed in any.
And what about this concept of danger then within the legislation? What did you, obviously you accepted that the pandemic was a danger, that COVID was a danger, but what other things may have featured within that? What is meant by danger, do you think?
It seemed to me that it was intended to be quite a natural reading of the word, and so actually it's quite broad, and I think there are quite a lot of things which could come under circumstances of danger. So as I say, for me there was no doubt that a global pandemic is going to fall under that, but there were some interesting cases that I looked at when I was researching that point. when I was preparing for the case, which aren't necessarily obvious from the legislation itself. They include that the circumstances of danger don't necessarily need to be generated by the workplace. Also, even the danger or the harm that might occur from the danger doesn't need to occur at the workplace. So I thought those were some quite interesting points. As I say, actually, it is quite a broad reading of the word. I think it's the first part of the legislation, and actually the following aspects of it then narrow it down. And I think the circumstances of danger themselves are intended to be quite broad, because it's then narrowed down by the claimant's belief in its seriousness and things like that.
Yeah. And what did the judge consider to be the important factors in this decision then, in terms of whether there was any link or any circumstances in which danger existed?
So as I say, whether there was danger itself wasn't an issue in the case, and the tribunal agreed that the pandemic very much created circumstances of danger. Where the claim fell down was in relation to the ability to avert that danger. So the tribunal did find that the claimant believed the danger to be serious and imminent. It's right that he took a lot of precautions in order to safeguard his family. Obviously, as I say, he had a family member who was shielding. And in fact, he went above and beyond the government guidelines, which, you know, as I say, in the summer of 2020 started to relax a little. He decided that for, you know, to protect the safety of his family, to continue shielding to a much greater extent than was, you know, required by the government. And so we did find that the danger was both serious and imminent. But the next part of the test is that he couldn't have been or reasonably expected to avert the danger, and that was really the main issue, I think, for the judge in this case, because she did find in the end that actually the danger could have been averted by complying with all of the government guidelines at the time. So obviously that included socially distancing, washing hands, wearing face masks and things.
Yeah.
And the fact that the claimant didn't feel that those were sufficient, the judge found couldn't be the respondent's responsibility or fault.
So as with most things in employment law, it comes down to what's reasonable, doesn't it? And common sense. And if the government guidelines are saying one thing, then fine if you want to go above and beyond, but what's reasonable for an employer to have to achieve is usually less.
Yes, yeah, and I think that probably has, you know, far-reaching implications for other employers or employees in similar situations. Yeah.
So why did the employee ultimately lose his case then, aside from your winning advocacy?
So as I say, the issue turned on the ability to reasonably avert the danger. So what that meant was that the danger didn't persist when the claimant refused to return to work, which is a part of the test. So it didn't persist because he could have averted it by following all of the guidelines, even though he didn't feel that would have averted the danger. Yeah. And so that meant that the reason for his dismissal wasn't unfair. It wasn't that he was refusing to work while a danger persisted, because it didn't persist, if that makes sense. But instead it was for his unauthorised absence, which the tribunal found was a fair reason in the end.
Yeah. And so obviously the COVID risk is now past, we hope, significantly reduced, so we might not get this type of case again. But are there any tips for employers or HR professionals that we can take from this?
Yeah, so I think that, I mean, obviously there must be, I would assume, plenty of cases where employers and employees were in very similar situations and didn't feel they could return from work if they did a job that didn't enable them to work from home. As I say, there was the one prior case in the EAT, Rogers, I haven't personally seen one since, and I think given the short limitation period in employment tribunal claims, I would have, I think we would have expected to have seen them all by now if there were any more in the works coming through. But the section can obviously apply in other cases. It worked very well in relation to the COVID cases, but it can be more wide-reaching, I think. If an employee, in terms of advice, if an employee raises an issue of not wanting to work, or wanting to work perhaps in with a different colleague in a different location, different circumstances, that I think should raise a bit of a flag for HR professionals, to think about this section and all of the components. Is the danger that they're referring to something which could be classed as serious and imminent? And perhaps if they are raising issues but they continue to work through it anyway, then they're potentially not so serious as to come under this piece of legislation.
One area that I've always thought this section might be a bit more useful in is where you've got mental health difficulties at work, which we see so many these days. So where you've got an individual who is being bullied or says that they're being bullied, and then there's a risk to their mental health, and that's usually if they've already had time off before. So I've always thought it was a bit of a possibility for cases where you might not have a disability, but where you might be on the brink of a mental health injury, that could be a serious and imminent danger. Would it work in a case like that, do you think?
I think it definitely could be used for in some cases in relation to mental health type danger. I don't personally know of any cases myself where that argument has succeeded, but I think, if it's something that can be classed as, the danger being classed as both serious and imminent, so I would say it, potentially has to go beyond a kind of general bullying, but because it has a certain level which it has to reach in order for the section to apply, and also obviously you'll have to think about what other steps could it be said might be done to avert the danger. So obviously where this case fell down was that there were things that could be done, so I think there'll be potentially could be quite an onus on the employee to raise a grievance about their issues, perhaps to ask their employer to sort it out, and change their perhaps working environment, working hours, the setup that that could potentially help avert the danger, other than just not returning to work. So I see no reason why it couldn't be used, but it's not an easy claim to bring. There are a lot of aspects to it which will have to be considered.
Yeah, sure. Thank you for that. And one thing that I did notice in the judgment was that the appeal officer, and it's interesting that you said that there was a disciplinary that took place in the claimant's absence, but the appeal officer wasn't able to give, or wasn't present at tribunal to give evidence. And that sometimes happens, doesn't it, where witnesses move jobs and it's a challenge for the employer. I just wondered, were there any challenges around that, or what do you do if the witness has moved on and you can't get them back?
Yeah, I think it's certainly a risk. I think, and there's specific case law which actually, when I'm representing a claimant, I almost always refer to, which says, that the respondent very much puts themselves at a risk if they don't call a relevant decision maker. Obviously, our defence is very much relying on why this decision was made, and so generally the tribunal will want to hear from that decision maker in order to properly understand why the decision was made, but obviously that's not always possible, and as I say, in this case, luckily we had giving evidence the actual dismissing officer who made the original decision, and he was available to give evidence. In relation to the appeal, we also did have documented minutes of that appeal, and the decision letter, which was quite detailed. There was also a good reason why the appeal officer wasn't present. They no longer worked for the respondent, and so it'd be quite difficult to ask them to to return and be a witness for the respondent. So, I mean, in different circumstances, perhaps there would have been more of a risk. I think there was enough mitigating factors that I wasn't too worried about it in this case. But where there's really something to, a very strange decision has been made, really the tribunal is going to want to understand from the decision maker why that decision was made.
Yeah, particularly if you don't have that good contemporaneous notes or minutes. And also in this case, the claimant represented themselves, and we obviously refer to litigants who don't have any legal representation as a litigant in person, which brings challenges for both us as lawyers and for judges. What challenges were there in this case, or are there for people acting without legal representation, and how can we point them towards help?
Yes, I mean, I think it was, I'm sure it was, and always is very difficult for litigants in person, particularly where the other side have counsel representing. They might feel a little kind of outnumbered. And there are difficulties for everybody involved that quite often stem from a lack of understanding, not through any fault of their own. I mean, I found, I'm sure is quite often the case, that hearings can take a lot longer. I mean, in this case, we were originally listed for 4 days and went on to an additional day and lasted 5 days with a reserved judgment as well. And I mean, the judge in this case actually was fairly interventionist and quite helpful in terms of, identifying to the claimant when he was asking questions perhaps which weren't totally relevant to the issues in the case, which were obviously very important to him and which he felt very strongly about. But in terms of what the judge and the panel had to actually make a decision on in terms of the issues in the case, that the judge in this case in particular, I thought was very helpful in terms of pointing in the right direction, just so that we stayed as on point as possible and so that the claimant had his best case to put forwards.
Yeah, I think that's a fair point, and that certainly was the case in a decided against the litigant in person a couple of weeks ago, that it's trying to stick to the list of issues really, and to ask questions as to those legal issues, which is going to be the most helpful, because there's always a wider context, isn't there, that you can sort of go down rabbit holes if the judge doesn't keep you to those issues.
Absolutely. And as I said, it is difficult for a litigant in person because the issues which are important are the legal issues, and they're potentially and probably the bits which is harder to get your head around as somebody that's not legally trained. And what feels really important to them and is at the forefront of their mind might not actually be relevant to the decision at all, but might feel really important to them and something that they want to focus on. So it is important to have a level of direction from the judge, I think.
Yeah, and also I don't know if you find this, but sometimes if you're acting for a respondent against the litigant in person, then sometimes the respondent's witnesses can feel as though the claimant's getting more help, and you need to sort of balance and manage expectations outside court, don't you? In terms of, that's normal for the judge to make sure that parties are on an equal footing and the like.
Absolutely.
Great. Well, thank you so much, Louisa. That was really interesting and useful case to hear about. And we're going to hear from Ollie now. Ollie, hi.
Hello, Heather.
In terms of Ollie's experience and expertise, Oliver was my pupil quite a while ago now, and is experienced in all kinds of discrimination and Employment Rights Act claims. You've got loads of multi-day hearings under your belt now, Ollie, which is great to see, and some quite interesting decisions to the EAT as well. So practice is really going well for you in employment sense, and of course you've got a broader practice as well, which sees you doing family work and broader civil litigation as well. Is that a fair summary, Ollie?
That's a fair summary, Heather, thank you.
Super. So Ollie, the case that we're going to hear from you today, super practical and really worth a look at. Some interesting and novel legal arguments put forward. There was actually one of our former colleagues and former member of Chambers, Spencer Keane, who was involved. And it's a pretty recent decision, isn't it, that you're going to look at, only handed down a couple of weeks ago. Can you tell us a bit about this case, Ollie, and what it deals with?
Yeah, so this is a recent EAT decision about the correct approach to calculating the EDT for the purposes of an unfair dismissal complaint. The interesting legal issue it deals with is whether the statutory concept of the EDT is bound by principles of contract. In particular, if a summary dismissal is in fact a repudiatory breach of contract by the employer, does the EDT take effect from the date of dismissal or the date on which the breach is accepted by the employee?
Okay, and obviously the EDT is the effective date of termination, and it's so important that we know when the contract is finished, because there's such short time limits, aren't there, within our jurisdiction. You've got 3 months less 1 day to get your claim to the tribunal, and obviously that little bit of time can make all the difference as to whether the case is accepted or whether you've got to battle to see if it will be accepted or not. So what were the facts in this particular case?
Put simply, the facts were that the claimant was sent a letter on the 5th of February 2020, which he received on the 7th of February. That letter was headed "without prejudice" and opened by stating that it had been agreed that the claimant's employment would terminate by mutual agreement. However, the tribunal found that no such mutual agreement had been reached. The letter went on to give a final date for employment. It set out the payments to which the claimant was entitled and offered a further ex gratia payment if the claimant agreed to sign an enclosed settlement agreement. The pile-on and holiday pay and the various payments were made on the 14th of February. So the respondent alleged that the EDT was the 7th of February, being the date on which the letter was received by the claimant. And if that was the case, the claim was out of time. The claimant alleged that the EDT was the 14th of February, when the various payments were made. And if that was the case, then the claim wasn't out of time.
So we're just talking about that week's difference that would bring the claim in time or out of time, and whether it was the date that the respondent was putting forward, which is when the letter was received, or the date that the claimant relied on, which is when he said he was paid up effectively.
Yes.
And the letter in question, I think it was headed "without prejudice." Was it without prejudice, and what was that all about?
Well, interestingly, it was and it wasn't. The EAT was clear to point out that documents can include open and without prejudice correspondence at the same time. Yeah. So the sections of the letter which referred to termination of employment was open, and the sections of the letter which referred to the settlement agreement and the ex gratia payment, that was without prejudice.
So what did the tribunal at Watford, I think it was heard at first instance, what did the employment tribunal decide?
The employment tribunal decided that the EDT was the 7th of February, as contended by the employer. It further decided that the letter was sufficient to constitute a unilateral termination. The language was unequivocal, and taking the letter as a whole, the tribunal found it was a summary dismissal. Ultimately, it found against the claimant on those 2 points, which meant that all the claimant could do was argue that it was not reasonably practicable to bring the claim within the time limit, but the claimant sadly failed on that point as well, and the claim was accordingly dismissed.
So it seems that decision was taken at a preliminary hearing or an early step, because the disability discrimination claim was allowed to proceed, as I understand it. but the claimant decided to appeal on that point, on the unfair dismissal point, with these quite novel arguments around when the effective date of termination does take effect. And there were quite lengthy grounds of appeal. Doing the best that you can you summarise those lengthy grounds of appeal, what points the claimant was relying on?
Yes, so in short, there were 3 grounds of appeal. Firstly, the letter of the 5th of February did not give rise to an EDT of the 7th of February because the letter was inconsistent with the contractual requirements for termination. The attempted dismissal was therefore a breach of contract, and the contract would not be brought to an end until that breach was accepted by the claimant. Secondly, the letter of the 5th of February could not be construed as a letter of termination, given its spurious reference to a mutually agreed termination. And thirdly, that the tribunal erred in not extending time. Those are the
grounds of appeal that were put forward. What was the response to the grounds of appeal? What was the employer saying?
Well, the employer was effectively saying, as you would expect, that there was nothing wrong in the tribunal's decision, that the tribunal was perfectly entitled to reach the decision that it reached. And in respect to the EDT, this interesting legal point, the employer was saying this has already been decided. It's a settled matter of law, and again, the tribunal had not misdirected itself.
Yeah. And so the issue that the EAT had to decide, effectively the same as the tribunal, wasn't it? Whether or not the EDT was the earlier date or the later date.
That's right.
And what did the EAT, I mean, it's a pretty technical argument and difficult argument to make by the claimant. How did the EAT deal with it?
So the EAT surveyed the relevant case law. The starting point is an EAT decision dating back to 1981 called Robert Court and Charman. And in that case, it was held in very clear terms that the EDT takes effect on the date of dismissal, separate from any question about repudiation or acceptance of repudiation. Fast forward to 2012, and we have the Supreme Court decision of Guise and Société Générale. In Guise, the issue between the parties was when Mr. Guise's employment contract was terminated pursuant to the terms of the contract. And the Supreme Court held that the special features of an employment contract do not serve to disapply the usual principle that a wrongful repudiation only terminates a contract if and when it is accepted. And so it was, of course, argued on behalf of the claimant in Meaker that in light of this decision, the Robert Court analysis no longer holds good. Summary dismissal does not end the employment relationship. The contract is kept alive so that the employee can enforce a number of rights under it, such as the contractual disciplinary procedure. And it was also suggested that this would lead to uncertainty if there were 2 separate dates for termination under contract and under statute. But the EAT rejected this argument. It found no support in either Guise or Robert Court for the claimant's arguments. Indeed, Robert Court was decided on the assumption that the elective view of contract was correct. The EAT also disagreed that 2 separate dates of termination would introduce confusion. Rather, the Robert Court approach again chimes with the practicalities of what the ordinary employee would take to be the position.
Yeah, it would be an absolute nightmare if we had to deal with 2 potential end dates of a contract, one under statute, one under contract. That would just cause, in every case, an argument about jurisdiction where there already are significant difficulties anyway because of the short time and then the added time on for conciliation. It's already very technical and tricky, and that would just be a nightmare for a regular employee trying to understand when their contract had ended.
I completely agree. We don't want to introduce further questions about repudiation and whether repudiation has been accepted. Instead, we have quite a clear statutory concept which can be applied in its own right.
Did the EAT find any particular argument was stronger than the other that the claimant was putting forward?
Well, interestingly, the issue which seems to have caused the EAT most pause for thought is related to whether the letter constituted a termination letter. This letter, which was mistakenly headed as containing a mutual agreement to terminate employment, and of course the overarching test there is that the letter communicates that the writer is terminating the employment with effect on an identified date, or one which is unambiguously ascertainable, and that dismissal must be clear and unambiguous. And this troubled the EAT. The claimant emphasised that the mistake about the mutual agreement of termination and the fact that it was marked without prejudice and enclosed a settlement agreement meant that it can't satisfy that test. It can't be a unilateral termination of employment. But again, the EAT rejected that argument and held that as a whole, it was sufficiently clear and unambiguous to represent a dismissal.
I mean, you can understand why the claimant must feel extremely hard done by when they receive a letter that looks like an offer of a mutual termination, but has got enough wording in it, quite luckily for the respondent really, to get them over the line of terminating that contract.
Yeah, that's right. And it's also important to point out that the context was an influential factor. So it was held that the letter did not come out of the blue. The letter was preceded by discussions which confirmed that the claimant could not return to his existing role due to capability issues. The termination of employment had been contemplated during those discussions. But you're right. I think it's quite the claimant can feel quite hard done by, given that there were some ambiguities. But the lesson to take is that you have to step back and look at the letter overall. Is it conveying a dismissal? And in this case, it was held that it was.
Yes, I think there's a section in the judgment, paragraph 53, where it actually acknowledges that it's not impossible for a single letter to do both things, as you said earlier, be without prejudice and be an open letter terminating and communicating a termination of employment.
Yeah, precisely, and that's what the EAT said. A single document may contain both open and without prejudice material. It's all a matter of construction, but this certainly wouldn't be best practice, in my opinion. It's advisable to keep WP and open correspondence separate and clearly defined.
Yeah, for sure. And what about the reasonably practicable point? How did the EAT deal with that? Because presumably the claimant then lost again at the EAT, and he's got this backup argument about was it reasonably practicable, and presumably that didn't go anywhere either.
No, it didn't, and this was quite easily rejected by the EAT. The claimant knew the date which the respondent considered to be the EDT. It was held by the tribunal that it couldn't have been reasonable to consider anything other than this was a termination of his employment, and he knew that he was at risk of being ruled out of time. There were no reasons why it was not reasonably practicable to bring it within time. That mistake simply wasn't good enough. He was 6 days late, and that's it.
Yeah.
No jurisdiction. Well,
happily, we haven't got a situation now where the law on the EDT has gone into a state of uncertainty. So that's a positive. But there's, of course, always the possibility that the claimant will appeal to the Court of Appeal.
Yes, of course. It'll be good to get a Court of Appeal judgment on this point. I mean, there is another Court of Appeal judgment which I think effectively determines it, but whether or not the summary dismissal is a repudiatory breach of contract, I think was obiter in that case of revés. But it would be interesting to see what the Court of Appeal make of this case.
Yeah. Any final thoughts? Any tips of best practice? Obviously, this type of letter, isn't it? What should an employer be doing?
You need to be as clear as you can be Although the EAT and the ET decided in favour of the employer in this case, that may be different in a separate case when there are ambiguities in documents. To make it clear what you are saying. From a practical point of view as well, for employees and employment lawyers, you need to be alive to the time limits and acutely aware that the EDT is not really a creature of contract, and time limits will begin to run, even where a summary dismissal is in breach of contract, which is not accepted by the employee.
Super. Thank you so much, Ollie. And that
No
was
problem. Thank you.
Meaker that was decided in the EAT earlier this year. And I didn't mention, Louisa, the name of your case that you dealt with, which was for Abellio, I think, wasn't it? The name
Yes, Dunbar and Abellio London.
Dunbar. We'll pop both of those judgments on the website with a link to them. But thank you both so much. They were really interesting and useful cases to talk about. Thanks very much
for your questions, Heather.
Thank you, Heather.
Bye.